It'll be page 10.
Got it.
She didn't let that. That's all the arguments
Okay, you ready?
Yes.
All right, let's go. Let's roll, nerds.
When he's a fair to ID.
Win, come on up.
One up. Good morning, Mr. Nguyen. Sir, do you speak English, sir?
Yes.
And up to?
Yes.
Okay. Mr. Nguyen, you're charged with failure to identify oneself to a peace officer as a fugitive from justice. As a result, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On February 21st, 2025, officers observed the defendant run a stop sign at Carmel Lane or turning into Leewood, heading north in Harris County, Texas. A traffic stop was conducted. The officer requested identification, and the defendant provided a TDCJ inmate card with the name Dang Nguyen. The officer ran that name and came back to have some multiple City of Houston warrants, so placed the defendant under arrest. At JPC, they fingerprinted him through AFIS and found that his true identity was Dang Nguyen, and that found that he had a felony warrant for PCS.
Okay. Mr. Nguyen, I'm going to find that there's probable cause to go forward with your case. Can you run his license, please? See if he has a license.
It is not eligible, Your Honor.
Okay. You are not allowed to drive. You do not have a Texas driver license. Do you understand? Unless you have a valid Texas driver license and liability insurance in your name, do not get into a car. You will be signing an affidavit with me today promising that you're not going to drive, Mr. Lewis. I don't care what's going on in your life. I don't care if you have to go save someone and get in a car. Do not drive. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine, not to mention revoking your bond and putting you in jail. Do you understand?
Sorry.
If you want to drive, go get a license, get liability insurance, and then I will happily take this thing off. All I'm asking you to do is follow the law. Do not drive until you get those things and approval from us. That is the only condition that we are going to place on you today, Mr. Nguyen. You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Kimberly, and she will tell you if and when you have to come back to court. If she tells me she cannot get a hold of you because you're playing games or you've taken off, I will issue a warrant. No more PR bonds. You understand?
Yes, sir.
Okay. I'll have you come up here, swear to us that you're not going to drive,
Yeah, she've had a surety bond.
and then after that, we'll let you go.
Yeah, surety bond.
Okay, yeah, I mean, and so he also has something upstairs as well. So do you want the same day?
I want to speak to you about that. I think this will probably, that case will probably resolve this case, so.
Yeah, but we gotta put it in a day. I
I'm
mean,
gonna do the same day, but I think we could shop a little bit later.
it's okay, whatever you want.
Okay.
Okay, Mr. Nguyen, come on up.
Good to see you. Pleasure.
You too.
Good.
Wonderful. Always boring.
Silence the defendant involved.
Thanks. I would have more if I had more money too. I'm just,
Good to see you, Frank. I know, good to see you.
you too.
All right, Judge, was that state farm condition?
Raise your right hand. Is your name Penguin?
No, just,
Please tell me what's
Okay. Next, council is approaching on page 7, both pages.
hi Elena, you ready? Good morning. Happy Friday. So, Michael Love, come up.
It's two, Michael Love and Michael Love Jr.
Oh, really?
Junior and third.
Okay, Michael Love Jr. and Senior, come on up. Who's junior? And you are? The third. The third. Gentlemen, both of you are charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On February 20th, 2025, the officer who dispatched the First Baptist Church. A caller stated that a white pickup truck parked behind the Baptist Church and two Hispanic males exited the truck and were walking around the property. The officer arrived on scene and observed one of the ground level windows opened and a window air conditioner unit pushed in on the inside of the building. The officers then observed two Hispanic males exit the doors on the west side of the building. The defendants then turn and look at the officers and then run in the opposite direction for approximately 30 yards to C Street, run an additional 20 yards to First Street, and then turn and run an additional 30 to 40 yards. Due to the circumstances of the incidents indicating this was possible furthering progress with fleeing suspects who could have been armed, the officers drew their duty pistol and gave defendant Love Jr. several commands to get on the ground and allow him time to comply. He disregarded the command, so the officer took defendant Love Jr. to the ground. Defendant Love III ran around the building and then subsequently followed commands to lay on the ground. They were both contained. Defendant Love Jr. stated that they panicked, so they ran. The officer stated, "You looked right at me and knew I was a cop, but you still ran," to which the defendant stated, "I know, bro, it wasn't the right thing to do, sir."
Your Honor.
They look at the cop and they run.
Yes, Your Honor.
Cops never tell them to stop.
Exactly.
And what are they doing wrong? I guess, I mean, what is this, Minority Report? You know what I mean?
Yes, Your Honor. I don't have anything additional to say.
Guys, be careful. You know what I mean? How old are you, sir?
18.
You gotta be careful, man. When you start racking up convictions, life doesn't get easier, man. It gets so much more difficult. And the more convictions you rack up, you're only 18, man. Life doesn't get easier. You get bigger, fatter, you lose hair. It doesn't get easier. And the more convictions you get, the worse you make life. Life is all about money. And if you have money, then life is great. And you only get it with one thing. This or this. Hard work or knowledge. Going around picking up cases, that's not the right way. Don't pollute. Do you understand?
Sir.
I'm going to find no probable cause on both of your cases.
Thank you, Your Honor.
Take a seat.
Yes, absolutely.
State, are we expecting knowledge on those two?
Yes.
Thank you.
Hi, counsel. You ready? Hey, of course.
Your Honor, I'm here on Marina Mary. It's an arraignment.
Okay, do you mind bringing her? Are you here for Mr. Bresson?
Yes, Your Honor.
Yeah.
Yes.
Okay. Good morning, Miss Mary. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
Your Honor, on Sunday, February 23rd, 2025, officers observed a vehicle hit a curb median while traveling eastbound at the 10,500 Almeda Genoa Road in Harris County, Texas. A traffic stop was conducted. The officer smelled a strong odor of an alcoholic beverage on her breath and observed her to have glassy eyes. The defendant admitted to drinking the 1 tequila sunrise alcoholic beverage. SMSTs were conducted. It was a 6 out of 6 on the age in, but they transported her to JPC for the other test due to rainy weather and the defendant being wearing heels. She then at JPC refused the rest of the SMSTs and blood warrants signed.
Okay, Miss Mary, I'm going to find that there's sufficient probable cause to go forward with your case. Have you run her to see if she has any priority to BIs and if she has a license, please? Miss Mary, I'm going to, like I said, find probable cause. I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using either, I will revoke your bond, put you in custody. Do you understand?
He is eligible if he has custody.
Great. As long as you have valid liability insurance in your name, as well as the license, you may continue to drive. If you do not have either, then you may not drive. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with counsel and they'll tell you if and when you have to come back to court. If they tell me they can't get a hold of you because you've gone AWOL, I will issue a warrant for your arrest. Don't pick up any new case. All right? For now, I'll have you sign a resale Victoria. We'll have you get with Felicia if your bond conditions, then you're free to go, man. All right.
Thank you.
Thank you.
All right, Judge, next is page 2. Please, come on up.
You said page 4?
Page 2, cool.
Good morning, Mr. Cooley. Mr. Cooley, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On February 21st, 2025, an officer observed a white Nissan Sentra without a front license plate. A traffic stop was initiated. The officer made contact with the defendant driver. The officer observed the odor of marijuana. The defendant admitted to having a cigar blunt with marijuana inside the vehicle. A probable cause search was conducted. The officer observed an electronic scale in the front driver's side door panel, a full cigar with marijuana inside tucked near the passenger seat and center console, and a large plastic bag containing approximately 1.06 ounces of marijuana on the passenger floorboard. The officer found a box of sandwich-sized Ziploc bags and one separate Ziploc bag containing marijuana residue. The defendant was identified with his Louisiana ID.
Can you run him to see if he has a Texas driver license, please?
Yes, Judge.
Mr. Cooley, I'm going to find that there's probable cause to go forward with your case. So the only condition I'm putting on you at this time is you are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. Do you understand?
Sir.
If you do not have either, then you are not allowed to drive. And I'm making that a condition of your bond. If I find that you do, then I will put you in jail. Do you understand? Do you have the ability to hire a lawyer, or would you like to apply for a court-appointed lawyer? Okay, I need you to fill out an application for me to see whether you qualify. So Deputy Edgegon is going to give you an application. I'll have you fill it out. I'll take a look at it. Do not leave until you sign our bond conditions, though. Do you understand? Okay.
So nothing is copied.
So you do not have you don't have a Texas driver license. So you're not allowed to drive. This is an affidavit that you're going to be signing with me today. I don't care what's going on in your life, Mr. Cooley. I don't care that you have to go to work. I don't care that the baby has to go to the hospital. If you don't have a license and insurance, do not drive. Do you understand? If you want to drive, go get a license, get liability insurance, and I will scream with joy taking this off for you. But until that point, don't. All right, I'm gonna have you swear to us that you're not gonna drive. I'll get you to Victoria for your sign your reset, and then a deputy at your going will give you an application. All right, please.
All right, Judge, next is page 4, Gutierrez.
Raise your hand. Is your name Luan Cooley?
Yes.
Is someone from?
Oh, I have a lawyer online,
Oh,
so I guess next we'll, and Leonard is the last name, but the defendant, Leonard. Bottom of 6.
okay.
You are Rachel Gutierrez. Ms. Gutierrez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you now.
On February 23rd, 2025, at approximately 3 o'clock in the morning, the officer observed a vehicle fail to signal lane changes twice and disregard traffic control devices, changing lanes over solid white lane markers, and then return to the lane it was already in. The temporary tag that the defendant had on her vehicle was expired as of January 17, 2025, and was voided. The officer continued to follow the vehicle, and the vehicle repeatedly failed to drive in a single lane despite another vehicle in front of it. The vehicle was also clocked traveling 60 miles per hour in a 50-mile-per-hour zone. A traffic stop was initiated. The officer made contact with the defendant driver, and she was identified by Texas driver's license. The officer observed red, glassy eyes and the odor of alcohol emitting from the defendant's person. The officer also observed the odor of marijuana emitting from the vehicle. The defendant admitted to consuming 2 beers and admitted to smoking a blunt while driving until the officer pulled her over. The defendant stated she was headed north, and she stated she was headed home, but her home was in the opposite direction as she was traveling. SFSTs were conducted. 4 out of 6 clues observed on the HTN, 4 out of 8 clues observed on the walk-in turn, 2 out of 4 clues observed on the one-leg stand. The defendant consented to provide a blood specimen.
Okay. Any prior DWIs? And can you?
No prior DWIs, and her driver's license is eligible.
Okay. Ms. Gutierrez, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming either, I will revoke your bond, put you in jail. No more PR bonds.
Okay.
Do you understand? Ma'am, do you have the ability to hire a lawyer, or would you like to apply for a court-appointed lawyer?
Bye.
Okay. Deputy Miranda is going to give you an application. I'll have you fill out an application or sign a receipt. Victoria will get police you for your bond conditions, and we'll take a look at your application.
Okay.
Please.
All right, Judge, next is page 6. Counsel's approaching on
Mr. Evans.
Leonard Marcus. Come on up.
Good morning, Your Honor.
Hey, how are you?
I'm great, Judge.
Here we go. I got Mr. Leonard coming up.
Thank you, sir.
Stuff on the bench. That right here.
All right. You are Marcus Leonard.
Yes.
Mr. Leonard, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. Just so you know, you're not here alone. Your lawyer is here with you, but on Zoom as opposed to being in person. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. Okay.
On February 21st, 2025, in Harris County, Texas, officers met with a complaining witness as a walk-up.
Wait, hold on a second. Do not talk. Okay.
Officers met with the complaining witness as a walk-up. Complaining witness stated that on February 19th, 2025, he and the defendant with his father stated that they were discussing who was stronger, and that the defendant eventually felt disrespected by this. Complaining witness stated that the defendant then pushed him into a bathtub and then told the complaining witness to leave. And when the complaining witness was grabbing clothes, the defendant pinned the complaining witness and struck him in the eye, causing an orbital fracture.
So it's son. So I see that he's a prior assault. Same complaining witness?
The one from 2008?
Yeah.
No, I don't believe so, Judge.
Okay. Have you ripped, or have you spoken to the complaining witness in this case?
Yes.
What is his wish?
No comment.
Okay. Did you hear that, Mr. Evans?
Yes, yes, I know Mr. Leonard very well, 20 years. I'm very familiar with the situation, so I understand completely.
All right, so Mr. Leonard, I'm going to find that there is sufficient probable cause to go forward with your case. It appears that a protective order has been issued on the 22nd of this month. I would get to know it. If you do something to violate this protective order, then the state can and probably will file a violation of a protective order. It's one of the worst cases you can pick up. Do you understand? I am also ordering you as a condition of your bond not to have any contact or not to be in possession of weapons. If I find that you have contact with the complaining witness in this case, likewise, I will revoke your bond, put you in jail. No more PR bonds. Now, you've got a great lawyer because you have one. I will waive your appearance. You don't have to waste your time coming to court, but stay in touch with Mr. Evans. He'll tell you if and when you have to come back to court. So do you mind filing no contact in the weapons, please? So for now, I'm going to have you go to Victoria, sign a reset. We will have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then after that, you'll be free to go. Do not leave until you sign our bond conditions, though.
Thank you, Judge.
Hold on. I need to. Oh, you
I
got
came
it?
by yesterday. I came by yesterday.
All right. Have fun, man. Have a good weekend.
Okay, thank you, sir.
All right, Judge, next is page 8, McKelvey. I can see that difference.
Hey, Brian. About your guy,
He hasn't been brought up yet.
still no. Do you think we'll get him?
Maybe,
Are you, can you be here Monday? If we don't get him today, can you be here Monday?
Yes, and I think that's what we're anticipating on doing. I talked with the chief, talked with the coroner. I think the plan will be to roll into Monday.
Okay.
Find out. This, you may recall, this is the issue. This had the competency questions. This was the gentleman who we did competency order. He'd been sent out of state to Louisiana. We did get that back. It had some issues, and he was on a 90-day mental health PTI. So there are some issues, and I need to see what state he's in. So.
And I just have some concerns now about.
Obviously, because it's number 4.
And if he's not going to be accepting DDRP, I mean, I think it's leaving us with very little options here. And I just can't do conscious.
So you want DDRP?
Well, I don't think DDRP is acceptable.
What do you think?
Well, we did a TRAS before in order to see about that. The TRAS, during the TRAS, they said, well, it's hearing voices, so we can't really continue the TRAS. And then their recommendation was we can't accept them in our DDRP because there's been a history of aggressiveness with the staff. And so we tried to go that route and just didn't find any available kind of resources. And so that's where we thought, well, maybe the best resource is a mental health PTI. And that's where things were at until, at least to my knowledge, until I got that email.
Okay. I guess we'll roll it to Monday. We'll figure out.
Yes,
I'll look at it.
Yeah. Okay.
Okay. Thank you, Judge.
Thanks, Brian. You are Ms. McKelvey.
Yes, sir.
Ms. McKelvey, you're charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
On February 21st, 2025, officers observed a black SUV traveling northbound on the Gulf Freeway at a high rate of speed at 98 miles per hour. The registration was expired as of February 2024. A traffic stop was conducted and the officer detected a strong odor of marijuana, and tests were conducted. It was a 6 out of 6 on the HDN, a 7 out of 8 on the walk and turn, and a 3 out of 4 on the one leg stand. She consented to breath, which came back to a 0.139. That's intersection when the traffic light was red. The defendant almost crashed into another vehicle before stopping, so a traffic stop was initiated. While the defendant was stopping, he ran into a chain link barrier that was blocking a private property. The defendant, the driver, was identified by his Texas driver's license and stated that he was coming from his sister's residence. The officer observed the defendant to have bloodshot eyes, slurred speech, and odor of an alcoholic beverage. The officer asked the defendant to exit the vehicle, and the officer observed him to be unsteady on his feet. The HGN was a 6 out of 6. The defendant was then detained. He advised that he had a handgun under the middle console. The SFSTs were conducted at the intoxication room, which was a 5 out of 8 on the walk and turn and a 2 out of 4 on the one leg stand. The DIC was read and consented to breath, which came back to a .150 and a .145.
Okay, any prior to be license, does he have a license?
Your Honor.
Yeah.
And his driver's license is eligible.
Okay. Mr. Mendoza, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, your bond will be revoked. You will go into custody. No more PR bonds. Do you understand? Now, you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them, and they'll tell you if and when you have to come back to court. For now, I'll have you go to Victoria, sign a reset. You'll get with Felicia for your bond conditions, and then you're free to go.
No weapons?
Yeah, I guess so. Right.
Thank you, Your Honor. May I be
Thanks, Ken.
excused?
Yes, ma'am.
Next judge is page 11, Rios.
Come on up.
Good morning, Judge Mayor. We are defending on this case.
Morning, Mr. Rios. More. So you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Your Honor. On February 20th, 2025, officers were dispatched regarding a DWI at the 14,700 block of Wallaceville Drive in Harris County, Texas. The officer observed the black Dodge Charger parked at an intersection when the light was green for motor vehicles to proceed forward. The officer utilized his horn to get the driver's attention, but did not get a response. He then made contact with the defendant, who was the driver and sole occupant, and observed the defendant to be asleep while the motor vehicle was operational at the time of the offense while his foot was on the brake. The officers were able to open the motor vehicle through the front passenger door to turn off the car and observed red bloodshot eyes, slurred speech, a strong odor of alcoholic beverage, and chunks of vomit on the defendant's shirt. The defendant denied consuming any alcoholic beverages and stated that he was coming home from work. The SFSTs were conducted. It was a 6 out of 6 on the HGN, a 3 out of 8 on the walking turn, and a 2 out of 4 on the one leg stand. The DIC was read and the defendant consented to breath. The results are a .140 and a .141. He was identified by his driver's license.
Got it. Any other prior DWIs and license?
No prior DWIs and his license is eligible.
Got it. All right, Mr. Rios, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming any, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? Yes, sir. Now, because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them, and they'll tell you when you have to come back to court. If they tell me they can't get a hold of you, you pick up a new case. If you're a danger to my community, I only have one place for you. Do you understand? Yes, sir. For now, I'll have you go to Victoria, sign a reset. We'll have you get with Felicia for your bond conditions, and after that, you're free to go.
Thank you. I'm ready to accept that.
Yes, ma'am.
All right, Judge, next is page 14, Torres, come on up.
You're Ms. Torres Rodriguez. Ma'am, you were charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to be silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On Saturday, February 22nd, 2025, officers were dispatched to a theft call for service at the target at 22165 FM 529 in Harris County, Texas. The LPO advised that the defendant was observed on video placing items in her shopping cart. She then went to a different aisle and began placing those items in her purse. The defendant then exited the store past all points of sale with those unpaid items inside of her purse. The reportee then escorted the defendant back into the store and had the defendant empty the stolen merchandise from her purse. The total value of the item stolen was $469.92.
Got it. Okay, Ms. Torres, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to go to any Target whatsoever for any reason. You understand? If I find that you go to a Target or if you pick up a new case, I will revoke your bond, put you in jail. No more PR bonds. You understand? You mind filing that? No going to any Target, please. Do you have the ability to hire a lawyer, ma'am? Would you like to apply for a court-appointed lawyer? Or what would you like to do?
I can see.
Okay, I'll have you go to Victoria, sign a reset. I'm going to have you take a seat in the jury box while we'll get your bond conditions. We'll have you sign it, and after that, you'll be free to go.
Hey, Judge.
Get you, yeah.
All right, Judge. Next is page 15. Vasquez, come on up.
You are Erica Vasquez.
Yes, hello, sir.
Ms. Vasquez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
On February 23rd, 2025, officers were dispatched to the 23,900th block of FM 529 Road in reference to a major accident. The officer made contact with the paramedics who were providing care to the defendant and stated that the defendant required transport to the hospital due to complaints of pain and high blood sugar levels. The witness stated he observed the defendant still sitting behind the wheel of the vehicle when he pulled over to assist her after seeing the vehicle stuck in the ditch. The defendant stated she failed to maintain a single lane, which caused the vehicle to go off the roadway and enter a ditch filled with water. The defendant admitted to drinking 2 bottles of Smirnoff and was observed to have red glossy eyes and the odor of alcohol on her breath. The defendant was transported to the hospital. The officer observed an open 24-ounce twisted tea can, which was cold to the touch in the center console.
So drinking while driving?
Yes, Judge. SMSTs cannot be conducted. The blood warrant is signed and executed.
Valid Texas license? Ms. Vasquez, I'm going to find that there's enough probable cause to go forward with your case. I am now taking away your privilege to drive. You are not allowed to drive for any reason. Do you understand? If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months of jail and a $500 fine every time you drive. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what your reason is. There's no justification you could give for getting in the car and driving. Do you understand?
So he does have an eligible driver's license.
Yeah, please have the phone call silent.
Any prior DWIs?
No prior DWIs, Judge.
This is the affidavit that you're going to be signing with me. This is a court order that you promise you're not going to drive. Do you understand, Ms. Vasquez? I'm also ordering you as a condition of your bond not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail. No more PR bonds. Do you have the ability to hire a lawyer? Or would you like to apply for a court-appointed lawyer, ma'am?
I have a lawyer.
You already have a lawyer.
Yes.
You hired one, or you're going to
Yeah,
go?
I hired one already.
Oh, Judge, I guess it just signed off.
So what we'll do is we'll just have you take us, well, first now, I'm going to have you come up, swear to us that you're not going to drive, and we'll get you to Victoria, sign and reset. You will get with Felicia for your bond conditions, and then we'll just have you wait for your lawyer and back. Okay?
So can sign the bond as a defendant.
Judge, that's it for now. The other ones are waiting on their attorneys before we can follow them up.
Okay. Counsel, you need him. Okay.
Yes. He's only going to know that you're not operate a motor vehicle without a valid ticket and all of that. And you know, I'm straight back. You don't sound reasonable.
Go ahead and sign for your research.
Mary, Marina, right here,
Ready?
Yes, Judge. Good morning. How are you?
Hey, what's new?
I have an off docket. Is that okay?
No problem.
Okay. The cause number is 255-2517. This is for Brandon Brown.
Okay.
I am not his counsel on the misdemeanor case. I'm his counsel on the felony case. I was informed from misdemeanor counsel that we wanted to put him on the docket. He's on the docket Monday here because he didn't have a felony bond. And so.
We want to, no, I think that.
Right? Okay.
We wanted to.
Like figure out what was happening in felony.
Right. No, and here, because he just picked up a new case. He's on bond for at least one case with us. So we're going to put it to speak about his bond situation. That's
Yeah. So I just came back from felony. I was appointed on Tuesday. He did not receive a bond that day because he was on a parole hold. And then that.
Parole hold now?
No, it was lifted that same day that I was appointed. And we couldn't tell because I don't know if you remember on Tuesday, like all the defense attorneys were kind of locked out of the internet and I couldn't check. So anyway, parole hold's lifted. And so on Monday, we put him on for Monday in felony to get a bond there and probably hopefully resolve it that same day because the case is old.
Oh,
Yeah, it's from 2023.
right.
So just wanted to make misdemeanor aware.
Is that going to swallow this one up too, you think?
Possibly.
Yes.
Possibly.
Get the cost number?
Yes.
Is there a global offer?
There is no global offer, Judge. So he's got the 3 misdemeanors here and the 1.
He has two.
He has 2. But
He has
PC.
2 evadings and a PON. What
I got no PC, I think. Or is it still open? Did you guys know?
it was discharged, no PC. It's not dismissed yet, Judge.
It's not dismissed. Okay. So yes, technically, I mean, well, there's nothing that I can do with that. I mean, that's right.
Right.
So.
So just wanted to make the court aware. I don't know if y'all want to put him for Tuesday.
Okay. I have to let Ms. Strong know too. I don't, are we expecting?
I emailed her.
Mr. Smart here?
I think he came up.
Okay.
Yeah, he's back there.
Okay. So I don't know, maybe we'll see her. But yeah, we'll put it on Tuesday.
Okay. And then if we resolve it Monday, we resolve it Monday.
Okay, did you get the cost number?
I can Smart.
No, we're talking about, I was just curious about Mr. Smart. Let me give you the cost number. You ready?
Okay.
It's 255-2517. And then there's 2 cases for you to move.
2517?
Yeah.
Okay, what are we doing?
Just on Tuesday, 3-4. Both cases, please. Okay.
That's all I have, Judge. Good
Have
to see you.
fun. You too.
I just put 2 bond petitions in your queue now.
Okay.
McKelvey?
And you're attacked and you're.
You want to have you sign 3 documents? For the test, yeah. Are you sure? Like if it's, say. Starting Monday.
Attorney has
Hi, Carl. Ready?
You want me to have Robinson brought out? The boy from yesterday, we carried over from yesterday, he was here with his mother.
Yeah, I want to speak to him.
Okay.
Yeah.
I didn't know if you wanted me to sit over there for a little while or.
That doesn't matter.
It doesn't matter.
I mean, I don't want to keep you waiting.
Yeah.
You know?
Okay.
Yeah, if you don't mind having them bring him out. Mr. D, I'm sorry, not Mr. D. Mr. Butler. I was thinking Mr. Dixon for a second, but
Thanks. I have Mr. Flynn on the docket this morning for arraignments.
okay, you ready?
Yeah. Mr. Flynn?
Lynn. Oh, Finn.
Yeah. Yeah.
Finn, yeah. Good morning, Mr. Finn. Good morning, sir. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On February 22nd, 2025, at approximately 11:07 p.m., an officer was dispatched to 59 Northeast Cross Timbers on City Street. The officer observed a vehicle run a red light, take the exit, swerving in and out of lane number 2 and cross 3 lanes of traffic, almost striking a guardrail. A traffic stop was initiated. The officer observed the driver to have bloodshot eyes, slurred speech, and the strong odor of alcohol upon his breath. The officer had the driver and the passenger exit the motor vehicle. The driver consented to SFSTs and the defendant performed them. 6 out of 6 clues were observed on the HTN. 5 out of 8 clues were observed on the walk-in turn. 3 out of 4 clues observed on the one-leg stand. The defendant was read the DIC and consented to provide a breath specimen. The results were 0.141 and 0.138. The defendant advised he had 1 drink while at a bar, and he was the owner of the vehicle, and he was identified by his Texas driver's license.
Any prior DWIs?
No prior DWI, Judge.
Valid license?
Valid license.
All right, Mr. Finn, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, your bond will be revoked. You will go into custody. No more PR bonds. Do you understand?
Yes, sir.
Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them, and they'll tell you if and when you have to come back to court. If they tell me they can't get a hold of you because you're ducking and dodging, I will issue a warrant for your arrest. Just keep my city safe. That's all I want. You understand?
Yes, sir.
I'll have you sign a receipt with Victoria. We'll have you get with Fleischer for your bond conditions, and then you're free to go.
Thank you, Your Honor.
Right this way. All right, council, we're looking at April 29. So that's the updated.
There's all those provisions in this one. This is
Just have him before the night bell, she's given.
He says because he has started. All right.
So that'll give you that.
The probation officer did a motion, so they're doing it. So they just want you to motion and make sure that he's going and they send this.
David Daniels, come up.
Marcus Leonard? Marcus Leonard.
Good morning, Your Honor.
It's not a good morning. No. You are using my name on an occupational license and you're not in compliance with what you're supposed to be doing. It's unacceptable. If I find that it happens again, I'm going to yank it. I want to make sure that you're not using while my name is on the license. Do you understand?
Yes,
I'm sending you now for a drug test. I want to make sure that you're not using. And then if I don't know what I'm going to do, the first thing I want to send you for a drug test to make sure, and then we'll go from there. So we'll send you and then we'll have you come back.
Yes, sir.
This is who, Judge?
No, don't worry about it. I'll have
Okay,
tutorial.
thank you.
Thank you.
Well, then it's just for alcohol, is that okay? They don't test for alcohol, just as that for rapid.
I want to make sure that you can stop.
Yeah, that's okay. All right, Carl.
Judge, he's still in the process and they didn't send him up.
They have them process him at JPC, so they didn't bring him up.
Any questions?
You want me to come back later and see if they can get him?
Yeah, I mean, that's fine. And we'll be here for another, what, at least an hour and a half.
Can you call to see if they can get him?
He's on JPC.
Okay. Thank you, Judge.
Maria Torres? Maria Torres?
You want to stay with the organized space.
After bond issues right now, that's why. That's basically conditions on your bond. Do you have any questions about your bond conditions about your attorney? Oh, once you get an attorney, you can talk about your condition. I'm not for you on top of accounts. We can take with date. Basically says what you can and can't do when you're in bond. If you do so, you'll need to come back because you'll need to come back and not to clear March 31st. You look at it, fill out the affidavit when we show up. So, so, I mean, you're up in the lease now, and if you can't, if you get a time, you coming soon, the JDP, call the gym, that's the fast forward, but if you want to apply for attorney now, you rather do that, okay. If you can't, no, don't, you just write it down that you tried, okay, then we'll do the paper, and just see if you can do it. You forget.
Okay, I have to get
You have somebody that's looking for them, because, you know, the judge, the judge wants, that's fine, I didn't care about that, somebody, you know. Thanks for your.
Things to do, you sign 3 times, you're signing on the first one's going to be the bond conditions, since I'm drugs, no alcohol, the trespassing, firearms, special revocation, sort known law violations that appear in court. Especially with that, your next court date is April 30th. However, since you have the term code, not the term code, just like have full life, so don't be fairly hot. And then also for the drug testing, I'm gonna go out with you, is this your phone number? Starting, you know, everything that's as counsel assistant. Like, it has something every day. I think you text or like, you want me to text. It says yes. Give me a text. So, if you get a message that says yes, you do need to text, you're going to report to this address, but if you're going these hours, just make sure you respond to those messages. Yes, or right now. I don't think that you have any questions about sure any issues, getting the
Report to.
yes, that'll be totally fine. I totally, but normally they send it around like super early in the morning, so then we'll use it probably up there. If you have any questions there, it's 3,000 information. That's everything on the side. We don't do the shirts. Go ahead, sign. Second one, go ahead.
You didn't have a time frame on when you was about
The papers that I showed you. Thank you. Sorry about that. That's your condition of bond. Just your document stating I'm going to be.
Amy Rivera, come up.
You don't have to go over there.
I want to see how. Was he drawing in? I mean, was he brought up another?
Judge, this one was removed from DWI.
Do you have an offer on this case?
There's a probation, probation offer on there, Your Honor. It's on there as well.
That's right.
Do me a favor. On Ms. Rivera, you take Lockbrooks off, please.
Yes, yeah.
Right now, please. Do you have a lawyer, Ms. Rivera?
No, sir.
Let me express how upset I am at this case, how long it's been going on, and how much drama this has caused. You are now ordered not to consume alcohol or illegal drugs, unprescribed controlled medication. I'm going to put a GPS monitor on you so I know where you are at all times. I'm now also giving you a curfew of 9 p.m. to 6 a.m. If I find that you consume alcohol or illegal drugs, I will revoke your bond. No. Let's do this. Do you mind appointing her a lawyer now, please, so we can once and all, just take a seat for me in the jury box, man. You're not allowed to leave.
Judge, Mr. Daniels,
This case is 800 days old.
Mr. Daniels, it takes 3 days for the drug test to come back.
It's about the test that we took when.
I can do a rapid and it'll come back, but it won't test for it.
I know.
Okay.
Do both. I want to do the rapid and I want to do the other.
Okay.
Mr. D.
Yes, sir, Your Honor.
Hi.
Thank you, Your Honor. Judge, I am here on Mr. David Shaw. You had wanted me and the state to talk to you this morning after I'd gone and
were you able to get the video?
I got some investigation. I went out yesterday evening and I went to the apartment complex where my client, Mr. David Shaw, resides. I did a.
You didn't have to go there, Mr. D. I mean, really.
I know, but I wanted to do the right thing, Judge. They wanted some information.
Well, I mean, really.
And I had to get the information for you. That's what we do.
Look at this guy. Okay, so how far is?
I walked it from east to west. It's 550 feet from the east to the west entrance. So, and he would have to be moved from his location to building number 29 in order to be outside of the 500-foot range of what the complaint.
So what's a reasonable? So, Blaze, what's a reasonable number that we can keep so that the distance, because I don't want him going anywhere near.
Right. With 200, because I know Mr. Dixon said it was about 500.
It's about 550 from east to west.
I don't want to have to eject him from his apartment.
Right.
But at the same time, I don't want him going anywhere near her.
But we have to do something because he's in number 320, 321. Yeah.
100, is that sufficient?
I think that would be good. Yeah, he have to, 200? No, it's not. That won't make it, Judge, because he stays in 321 and the CW stays in 323. So he's.
They're neighbors, essentially, Your Honor. Okay.
I don't know how to do it because I just don't want him going near her. And that the possibility of them running into is just way too high.
I agree, Judge.
I don't know what to do.
See if we can, I could talk to the management and see if they can.
He's in custody right now? Or?
Yes, sir. He has a fellows in opinion, so I could talk to management and see if there's a possibility of moving him to building 20.
Well, hold on a second. I mean, what is the cause number? Do you mind? You have it handy?
255-3185. 255-3185.
Do you know if he's planning on parole?
No, sir, not to my knowledge. He's not working at this time, Judge, and he still has that felony pending. So.
I mean, while he's in custody, I guess it's a non-issue, right?
Yes, sir.
If in the event that you find out he's going to post bond or he has, at that point, I guess we can readdress it. But there's no sense in trying to move or do anything prematurely while he's still in there anyways, because.
He has my number, and I told him to keep in contact with me if he makes bond, Judge. So
all right, let's just keep it as is now. I'm not going to do anything because he's in custody anyways. He's not bonding out. So
we have a call set and today. So
all right. I mean, you still got the new cases, so that's going to take
Yes, Your Honor.
Okay.
3-time penitentiary.
Judge, so would you like to keep it at 500 feet as of now, or?
We'll keep it as is for now.
Thank you, Judge.
Sydney.
Thank you.
Hey, Trey, I'll push it through.
Hello, everybody.
The man, the myth.
Guy in the box that we talked about, it a little bit yesterday.
Hey.
Judge, I'm ready whenever you are.
Okay. Up at page 26, did you talk to the lawyer on that already?
Yes, Judge, she's here. Go ahead.
Oh, okay, got it.
He waived.
Okay. Yeah, okay. Mr. Beadle. Hey.
William Jones, you wanted us to come to docket today, and he's here.
I'd like to send him for a drug test, alcohol test. I want to make sure he's not using though.
If that's the court's prerogative, that's fine. However, he is checking into the Medicare clinic tomorrow after his rehab for a while.
How long has he been?
And I'll be very frank with you, the last time I was here with him, he looks like $1 million compared to the last time I saw him. And I've been speaking with him very frequently on the phone. I'm more than happy for you to talk to him, Judge, frankly.
Come up, sir. The last name is, this is Jones.
William Jones.
We're here because Mr. Jones doesn't have his interlock that he was required to, and he's been out in lockout for quite some time.
Correct.
Which is unacceptable, right? If you're in rehab, we have to know, and there are certain measures that we can take, but just if you don't tell us anything and you're just in lockout, that's a problem. I have a real big problem, and I don't know you. Everybody tells me it's little raindrops and gumdrops and little bunnies jumping in the woods, but how the hell do I know? So he's telling me that you've been in a rehab in Ohio.
Sir.
When?
The last setting that we were here, the prior setting to this, Judge, he got on a plane from the courtroom and went off to Ohio. And I actually forwarded the court his admission paperwork to that facility in Ohio.
What was the date of release from that program?
It was last Friday. I spent 8 days in the hospital detoxing, and then the rest of the time in the rehab. And, I'm trying to put together a forward plan. I'm not supposed to be talking too much, but to take aftercare and go back to another rehab here locally and work on getting better. And I'm being proactive with that, Your Honor. He's had to change insurance.
That's all we ask, because the problem is that some people can, and some people can't. Addiction, it's a lifelong, and it's a persistent monkey that's on your back that will never let go. It will constantly grab at you. So if you're not proactive about it, that's when it grabs you by the boo-boo, and it just doesn't go well.
Sir.
I just need to make sure that you're not using, number one. Number two, most importantly, that my public is safe, because I certainly don't want you in a car unless, everyone is protected. And the way we know that is that you don't have alcohol on board. So what I'm going to do now, because you've been so AWOL with regard to this, I'm now putting a monitor on your ankle so I know that you're not consuming. If it goes in lockout again, I will put you in jail. I want you to know that. I'm not going to do this again with you. Do you understand? You've been in lockout for a significant amount of time, and it's not fair, because I normally would put people in jail lickety-split for something like this. Do you understand? I will not play this game with you again. It is your responsibility to charge it on a daily basis. It is your responsibility to know what you are putting in your body, as far as, whether it be mouthwash, hair dye, a tequila lollipop. I've heard it all, and I don't care for excuses. It is your responsibility to know. You've got such a great team of lawyers. There's just no excuse. I will waive the fee so that there's no excuse for, well, I can't pay for this. I can't. No. Do you understand?
Your Honor.
What you do on your time is you. As long as I know that you're not using, I'm happy. Do you understand?
Yes, sir.
Okay.
I'll be happy once he checks into the manager point. He can alert the Jimmy's, the court, everybody.
Yeah, I guess we're going to give him the scram device today. Just keep us in the loop as far as the cases are too terribly old. It's not old. So just keep us in the loop of when he's released. You have to calibrate this thing on, I think it's monthly. So make sure that you calibrate this thing like it's supposed to. They have to download it. You've got to charge it. So make sure you know of everything you can and can't do. You understand, Mr. Jones?
Yes, sir.
If I have you come up here on another violation, it's probably not going to go well, just so you know. Okay? Okay, guys.
Understood. Thank you.
Can he be released from the jury box? Just take a seat. People will get you inside. She's going to have to talk with her. She's already ready.
Yeah.
Can I give you a costume, please?
Yes, Your Honor.
That would be great.
Tell me when you're ready.
I am.
5-5-3-2-8-4.
Sorry, 3-2.
8-4.
8-4.
On Mr. Lopez.
Yes, Dr. Lopez.
He has now a terroristic threat with us. He's got a prior terroristic threat,
Yes, Your
a
Honor.
kidnapping, an aggravated assault.
Yes, Your Honor.
Tell me it's all the same complaining witness.
Some of them are the same complainant, some of them are the husband of the complainant. So yes, it's the same family, the same situation. I spoke to one complainant for about 30 minutes yesterday. It's a pretty severe alarm.
And this the threat you spoke to?
Yes, we're meeting ready.
Scared?
What?
Scared?
It scares me.
Well,
And she's, yes.
I'd like to do bond conditions.
Yes, would be absolutely requesting no contact.
Hey, Vic, I do need the lawyer on Lopez, that Mr. Haggard. I need to put bond conditions on him.
Okay, he has another case, he's talking to somebody out there.
Great. I need to bring homeboy out.
Almost started, so I don't know what to do with it.
They give you a one-time to go to. So, what you can wait on it as of now, because they're gonna remove it for you. They're gonna go tell you how to go about removing it and get it in 100 today. It tracks out.
Then you can hear the authorizations on one roughly.
Judge, do you have a removal order for the GI, for the interim? Do you have a removal document for the interim?
I don't want to.
No, I'm just getting the.
I know, but the problem is that if I do a removal order, it'll take it away from DPS in Austin.
Okay.
If he's caught driving, they're not going to know he needs an interlock. Whereas now, I'm going to leave it on, but I'm not going to hold him.
Okay.
you know?
Okay, thank you.
But explain to him that DPS has noticed he needs an interlock in the car, so if he's caught driving, there's no interlock. Yeah. It's going down.
So then driving, you need another one?
Yeah, I figured that out.
And then they'll just like go up before the next one, so it's okay.
It's cheaper. Hold on, you grab my stuff. So like, where do you live? My barber is, you know, sitting back here. I don't know, what do you consider that? You need to meet John Wilson, kind of like the hoops in his ears and take all the hand. Yeah, everybody's starting. I just like this here. I think so. I think. I'm more interested in getting discussing something that resolution.
Just after little bits of Barbies. And like from the different color. What about the building? Maybe let's find out. Do you know what kind of magnificent house?
I'm not gonna.
She's fine. I'm sitting on the couch. Yeah, no, Barbies. What was that?
That's all.
I know for sure.
So it's mom
Mom and sister.
and sister. The ag assault is
Mom.
mom.
The ag assault is actually dad.
Okay.
The prior kidnapping and the prior terroristic threat are mom.
And then this one is against mom.
Mom and sister, yeah.
Mom and sister.
Mom and sister.
I'll be back. Yeah, I'll send off. Okay. Kind of this call. We can talk about that.
There's a prior assault as well, Rehab. Is that with them as well?
The assault is unrelated. The Rehab is, let me see. Also unrelated. One of those prior criminal mischiefs is against dad. One of the criminal mischiefs is against dad. Excuse me, all of those criminal mischiefs are
And
against.
he's a true habitual, right?
Yes, Your Honor. That interference was dad, but sister is a witness.
Insurance?
Yes.
Next. Judge.
What's up, man? Hey, I meant to apologize to you for not showing up the other day.
You're fine.
I got like held up in that one because it was like 30 minutes or 45 minutes late than when I should have gone on. So I didn't get done until like well after 12. So by the time I would have gotten out there, it would have been done regardless. So
You were fine, Judge.
sorry about that.
No.
But I'm happy to do it anytime, you know.
I'll inform them, because I think they're going to try to get them together again.
I'm happy to do it.
It's, I show up and so the person who got me to do it was the chief of police. And so I was, hey.
Well, you're a prosecutor there, right?
Yeah.
Okay.
Yeah. I was like, hey, Ken, chief, where are you, man? You coming? He's like, no, I'm the middleman.
Oh, come on.
You did not explain that to me.
Come on.
Yeah. So I was like, okay, well.
Nice.
I'll give you a lecture. Okay.
Right.
Yeah.
Well, yeah, I'm happy to do it next time.
Well, thank you, Judge. I have an off topic down here, and I'll get a motion and a judge's sheet. Yes, sir. But first I gotta find that motion. Ready? 244-1078. Last name Vasquez. Johnny Vasquez. Yes, should be a motion to appoint investigator.
Oh, you know what? You just filed it today?
Yeah.
It's really, I know I saw it when I found it.
Where is it?
Do you have the envelope?
I'm sorry?
Do you have the envelope open?
Yes. 978-95559. That is also the first time.
How long do you the other minutes?
You can take. Right.
Can I see license?
Yes. Permission to report, Your Honor?
Yeah.
Okay. Technically, this is ex parte, but you have fun. Come on.
If you would like to.
No, I don't care.
I-
Did you need money?
I'm not that jealous.
So, yes, but I need money a year ago. So our coin operated machine case, I had an investigator go to the scene and you had said yes.
Nathan, I'll sign it.
Okay. Thank you. It's last name Vasquez, first name Johnny. It should be in your queue now. I submitted.
I remember that case.
Yeah, I'm sure. I submitted the voucher and the auditor bounced it back because there was no order and I didn't realize that I hadn't done it. Thank you, Jack.
Yeah, for sure.
And with that, I will run away.
That's good job.
Thanks.
You don't have an amount on here, though. Is that going to be a problem?
No, Judge.
You sure? Because they
Well,
always.
if you don't mind writing like maximum, what's the normal amount? Like 800? I'm sure it was less
I
than
don't
that.
know, but you want me to sign it first and then?
We can do Judge.
I hate to say it, I staff this
Able to
out.
check
I
it
don't,
out.
because I don't, I think that there has to be an amount, right?
Usually there is an amount.
Every time I sign one, there's an amount.
So I do these so rarely.
I don't want you to get kicked out back
Yeah.
again, so I guess.
If you want to write an amount, that's up to you.
Yeah, I don't mind, but you want me to sign it first and then
you could
print
sign
it out, barcode it, and then I'll do it, or how?
Are you able to check it out, Judge? Like at the top to the right where it says delete?
I think what I've seen in the past is maximum of like either 500 or 800.
It should pop up.
And then I have to come to the court and ask for more. And it's not very much.
Go ahead and check back in, Judge. We'll do the barcode. You can check back in. Once you sign it,
How much is it? Is it 800 or, because I'll put whatever you need.
Well, I think in the past, the amount has always been written as a maximum amount. Let me see if I've got the bill on hand.
And then also for the drug testing, it's a good compliment. Starting Monday, Friday, and to receive messages from the system called paper help. It's going to tell you every day all the yes, it says yes, you have to report this address here.
No, I've got a rejection for the thing that they're saying.
Or your number page,
Commissioner Pro, Your Honor.
Yeah, hi, Michael.
Yes, Your Honor. Good morning. I'm here on Mr. Jose Rojas. He's in the courtroom, Your Honor.
Why don't you, hey, yeah, I guess I'll put pay.
So I would say maximum of 100. I think the bill is in the few hundred range. That's what I think I've seen in the past. Maximum of 5, maximum of 8.
I mean, I'll put, pay max of $800.
Thank you, Judge. Sorry for the delay. I didn't realize.
Stop. You said page 13?
Rojas, come on up.
Morning, Mr. Rojas. Morning. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. As you, I don't know if you know, but your lawyer is here with you, but he's on Zoom. Just it's not here in person. Okay.
On February 22nd, 2025, an officer was dispatched to a major crash call involving the defendant striking a parked vehicle in the Concord at Gulfgate apartment complex. The Houston Fire Department observed the defendant asleep behind the driver's seat. The officers observed the defendant to exhibit bloodshot eyes, slurred speech, and a strong odor of alcohol upon his breath and slow movements. SFSTs were conducted. 4 out of 6 clues observed on the HTN. 4 out of 8 clues observed on the walk-in training, and 3 out of 4 clues observed on the one-night stand. The defendant consented to a breath test, and the results were 0.125 and 0.121.
Okay. Any prior DPIs and a valid license? Mr. Rojas, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will put you in jail. No more PR bonds. Do you understand? Sir.
His driver's license is eligible.
As long as you have a valid Texas driver license and liability insurance, then you may drive. If you do not have liability insurance, car insurance, you are not allowed to drive. That is also a condition of your bond. Do you understand? Because you have a lawyer, I will waive your appearance. You do not have to come to court until your lawyer tells you to. So you must stay in contact with him. If he tells me he can't get a hold of you because you're playing games, you're not responding to phone calls, text messages, I will issue a warrant for your arrest. Don't consume alcohol, don't consume drugs, and don't be a danger to my community. Do you understand? I will have you sign a receipt with Victoria. You will get with Fleischer for your bond conditions, and after that, you'll be free to go, sir.
Mr. April 29th through May 1st.
April 29th through May 1st, Michael.
April 29th. Thank you, Your Honor.
Okay, cheers.
Have a good weekend, Your Honor. Bye-bye.
Have fun. Mr. Madrid.
Yeah, good morning, Your Honor. I've got a case on Monday at Christopher Torres.
Okay.
I had emailed your coordinator earlier and to give her kind of a heads up. No, we were hoping to possibly plea. We had done a PSI 2 weeks ago because we were going without an agreed rec. I'm not in trial today, but I've been in trial for the last week on a capital murder trial. We don't have trial today, but we resume on Monday, and I think it's going through Wednesday. So I was requesting if we could move it till Thursday, if possible.
Yeah, of course. I mean, if you're in trial,
Okay.
What's your cause number? You got it?
It's 2522707.
At the last,
But you said you did a PSI on which one? On this case? On something with him or with?
I'm sorry. I'm getting confused with what I'm doing here. We did a TRAS, and we were going to go without an agreed rec. We approached you last time, but you said, well, let's do a TRAS and then we'll talk about it.
Okay. Yeah, let's. I'm okay with setting it for Thursday morning.
Okay, thank you very much, Your Honor.
Yeah, for sure. We got you.
Okay, have a good weekend.
Thursday.
Thursday the 6th.
The 6th, right?
The 6th, yes.
Okay, cheers.
Thank you so much, Your Honor. Have a good weekend.
Sure. Good luck.
Thanks. Goodbye.
You're finally back.
Yeah.
In at 10, out at 11:30.
Friday. You have to come on Friday.
Wonderful. Okay. All right, come up, sir.
Just make sure he goes into the, like, to make it seem kind of.
What are you doing with yourself these days?
I am.
You in TSU?
Yes, I am a property manager. I'm in grad school getting a master's in counseling, and previously I was an adjunct professor last semester.
Fantastic. Well, that's great. You're doing great. You know, just we all fall down. You know, we all make mistakes, but the idea is that just no more, right? Especially when it endangers other people, right? Don't say anything. No, don't. Just, you're doing great. Why mess it up? You know what I mean? You're doing really good. So we're not going to do anything with you now. We'll let you keep going. Just don't forget to blow anymore. If it happens again, I'm going to yank it. You understand? No, now's not the time, because the problem is that I don't want you to say something that hurts you. You know what I mean? You've got a license. There's requirements with the license for you to have it. If you don't fulfill those requirements, I can't keep the license, you know?
Received.
Okay, I'll let you speak with Shatoria, and the Shatoria can always, you know, kind of be the in between, okay? If there's any issue. All right.
Let's train on that one.
Timothy?
First one is random drug testing. And so if you don't have like insurance and a driver's license with your name, don't drive. For the drug testing, this is a good number for you. So starting Monday through Friday, all month, you're going to receive messages each day that tell you either yes, you need a drug test, or no, you do not need a drug test. If it says yes, we're going to remind that I will address here, 26 hours that same day. This is your personal identification number. With that, make sure you're responding to the messages each day, that yes, received, you can all place it, you're getting them, legit compliance. If you change your number, if you're not receiving the messages, or you have any questions, or if you don't know, you can contact your trust services. Do you have any questions with drug testing? I'm going to have 3 times, 1 revelation, download these papers. Print out the conditions, give you your next court date.
Yeah.
Okay, that's all.
Case just open.
I'm gonna give her a list of cookies so they can talk. And let me know when you show your chair and start.
That's fine, don't worry about it.
Did you sign a Bob?
All right, ignorance for you is gonna be May 1st. Since I'm on the job, I think you have to put it here back to you, okay? You know, I think that if you want, but you're on staff days, you just saying I'm done, then I'll, you know, that's, you don't worry about copy your conditions, and then the other two, documents, you have to yes. Then you're on the stuff, so it's patient. On the work, so I'm gonna have you sign 3 documents within the day. Everything you're signing, you're gonna get a copy of. First one's gonna be your conditions that the judge will allow. That's gonna be the no drugs and alcohol.
Counsel, right? Yes, sir.
Then we want your leadership here.
I believe they're bringing him out, Mr. Lopez.
Mr. Lopez worries me.
Is there anything that's available that can be released other than the news?
I did your rip on.
Oh, yeah, I saw the rip in there, but no.
Nothing else.
Okay.
Can I talk to him real quick while we're waiting on your back?
You already filled out a motion, so.
Mr. Tyson, hey, are you ready?
I have a question, Your Honor.
Shoot.
On DWI, we are trying to work out an offer with, deal with the state, possibly a time served.
It's not a second, right?
No, it's just.
I'm happy to do whatever you guys want to do.
Okay, well, my question is, will you run the driver's license suspension concurrent with the DPS? No. Okay. Just asking, gotta ask, gotta let my client know.
I would run jokes concurrent, but this license, hell, she is literally been.
I understand, Your Honor. How about the surcharges?
Reward people when they deserve it, you know, but here.
Oh, okay. Yeah, since there was something not good happening or that happened, what about surcharges?
Of course,
okay.
That's what I'm saying.
Right.
That, yes, license.
Gotcha. I understand. Thanks, Your Honor.
Yeah, of course, Mr. Tyson. Coming up, Mr. Lopez. Yet another terroristic threat. Let's go through your criminal history, Mr. Lopez. 2012, burglary habitation. 15, assault, bodily injury. 15, criminal mischief. 20, criminal mischief. 16, criminal mischief. 17, suspended license. 18, interference with emergency request for assistance. 22, kidnapping. 24, aggravated assault of a family member. terroristic threat, evading arrest, terroristic threat, and now another terroristic threat. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Please.
On February 25th, 2025, officers were dispatched to a residence at 2715 Owen Cross Drive in Harris County, Texas. The complainant stated that in the first week of February, the defendant snuck into the residence via the garage door, and that she had been telling the defendant that he does not live at the residence and has to leave the location, but the defendant refuses to leave. The complainant, who's the mom, has been saying with the complainant two, the daughter, or the complainant one's daughter, the defendant's sister, at a different location because they fear the defendant. On 2/25, the daughter came to the location to retrieve the dog. The complainants had a verbal altercation about the dog being missing and the defendant wanting money from them. The defendant then threatened to harm both complainants, saying, "I'm going to beat the shit out of y'all. All y'all do is send me to jail. I'm going to beat y'all's ass up. I'm going to beat you up." The complainants advised that they are fearful for their lives due to the defendant's threats and his history of violence.
So we do have a history of violence where there are threats and aggravated assault against this family.
Yes, sir.
Mr. Lopez, they are terrified of you. The thing that you also need to consider is that you are a true habitual. So if you pick up a very serious felony, you could be very well looking at 25 to life. You know what I mean? 25 to life. You pick up a serious case. These are the things that you need to think about when they're out there in the free world. Do you understand? Sir, I don't want you going within 1,000 feet of where they live or where they work. You will get a GPS monitor if you are able to bond out. I don't know. At this point, you have not made bond, so I don't know if you're going to get out. But if you do, you must have a monitor on you, and I don't want you to go anywhere near where they live, where they work, where they breathe, where they put their head down, and you're not to be in possession of any weapons. Do you understand? Yes, I do. You know, I would venture a guess that probably 98% of the people that are in Harris County jail, and I don't know if I've told you this before, but are there because they have absolutely no self-control. They get upset and they wig out without thinking, if I say this, what's going to happen? If I do this, what's going to happen? This is what you should be thinking about every time you're out there. Can you understand? It's not hard, really. You're also not to consume alcohol or illegal drugs, and I'm going to randomly test you. So counsel, at this point, he's not made bond. We can just set you out for a couple weeks, wait for the evidence to come in. If he does get out, he needs to be here the next business day for all the conditions. And then I definitely want a GPS prior to release.
Understood, Your Honor.
Okay. Self-control. Okay, thanks.
Thank you, Judge.
All right, thank you.
Judge, we have an arraignment.
No, let me help them first,
Oh,
please. Good morning, Mr. Johnson.
Good morning.
Mr. Johnson, you're charged with terroristic threat of a family or a household member. That kicks it up to a Class A misdemeanor, so you're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement where they're offering you 150 days in jail with credit for the 53 days that you've done. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. Is this what you want to do?
Yes, sir.
How do you plead to the offense, sir?
Guilty.
I'm going to find you guilty and we'll follow the agreement, send you to 150 credit for the 53 days that you've done. Good luck to you, sir. Thank you.
Judge, we are approaching to deal with the BVR on Miss Danielle Free. I think it was last Friday or maybe the Friday
Brief
before
them up.
last, Judge. She missed it because she was out of town. She got the notice on a Thursday. She couldn't get back. She did try to go to pretrials to get it done, but they couldn't get it done.
Do the order now.
Oh, I know, but she did one this morning and she's negative. So.
Don't let it happen again.
Yes, sir.
If it happens again, I really sure want you arrested. You on notice now. No tolerance from the state board.
Okay, thank you.
She's PTI bound anyways, Judge, so we're just gonna.
Thank you.
Hey,
Judge, I just got appointed to Mr. Wyckoff this morning, and I was told I need to approach because he picked up a felony. He's in custody, Judge.
Did he make it up today?
Make it up today? Let me check, Judge, but I just wanted to see if we wanted to keep his bond the same or.
Oh, yeah. We've got a lot of.
I think his bond's set at 15,000 right now.
Yeah, we can't get him here. It's just.
Do you need him brought out if he's back there?
Who is it?
Mr. Wyckoff?
Wyckoff. Yeah, because we need to do conditions on him. Is he back there? Yeah. Yeah, do you mind bringing him out? Thanks. Counsel, you ready?
Hand down, Judge.
Hey, yeah, let me just.
Your Honor, do you mind if we hold on that case for a few seconds? It is a vehicular crime case. I want to make sure I can email that prosecutor if they want to go.
Which case?
Wyckoff.
Wyckoff?
It's an assault.
Oh, sorry, I clicked on the wrong person.
No, you're talking about.
They're right next to each other on the list.
Okay, sorry, come on.
Judge, I have Miss Erica Vasquez. She's in the jury box. She sent for arraignment this morning.
Okay.
I just want to approach, I guess, for bond conditions.
Yes.
I waived PC. I read the PC.
We've done it.
Already done? Okay.
Yeah, so just no alcohol, no drugs. I ordered her no to drive, because, she had an open container in the car, so she's not allowed to drive. So just, you guys are good whenever you want.
Okay, gotcha.
We've done the conditions, so she's good to go. Thanks.
Thank you, Judge.
Just please admonish her not to drive. Well, look, it's not absolute, but I want to know that she appreciates and then proactive and then let me know.
Sure.
Yeah.
Did you want to sign up? I know drop that today.
She did. She did, right?
Yes.
Yeah.
All right, there you go.
Yeah, I'm just leaving.
Yes.
Morning.
How is informal confinement from May 1st?
Yes.
Because he's saying higher than that. Can you go to these?
Yeah.
Go to Metro and break these.
Where do you go? Really late today. Or yesterday. Financial. Didn't it?
Okay, so it looks like you're returning with Jerk in your case.
I paid him all my money. What the fuck?
Okay, is that Gagliardi?
Yeah.
Okay, they filed a withdrawal yesterday.
And then I'll give the reset to free child for them, I'll call it. You're welcome.
Who's he gonna let me know this? I paid him all my money, bro. Come on, hell no.
So you may need to contact them about that.
I don't know. My people been trying to contact him for a week now.
Okay.
And he hasn't been answering the phone.
Well, we'll just have to address your bonds with the judge. Do you think you can make any bond?
I ain't making no bond. He better come to court.
Okay. And do you have any children?
No.
Okay.
All right.
Well, of all the days, right? The day they tell me something about That's another change. Yes. Yeah. I agree with you.
Actually, it's about but when I I'm not sure. Every time. And I got it. I think that. All right. Thank you. You're welcome. Oh, I'm from. Yes. And that's very impressive. Yeah, all the practices. Except waiting at institutions. You are not here. There's not a phone.
I'm sorry, I didn't realize you were out there. That's fine. It was.
This is Mr. Wyckoff.
Yeah. Morning, Mr. Wyckoff.
And Judge, I did want to make something clear to you. He was under the impression that his hired attorney would be here, Mr. Gagliardi, and so apparently that attorney withdrew.
When? He didn't tell me nothing. He didn't tell my people nothing.
Yesterday.
When I was supposed to come to court.
The thing is that you've been gone quite a while.
And I asked him when I got out of jail. I asked him, when was my next court date? He said he'll call you and let you know. He never called me back. That's what I paid him for, so he could tell me.
I don't know. I mean, I'll let you guys get into that. All I know is it's been a long time since we've seen you, Mr. Wyckoff, you know? So, do you know what conditions they put on the felony things?
I don't, Judge. Could you check that into the bond conditions?
Yes.
Thank you.
Alicia?
I'm pulling him up right now, Judge. It looks like there are none currently active due to the warrant and bond being denied. So they haven't set any new ones. And the warrant that was issued after the last conditions made them inactive now, the previous ones, correct?
Who's bond denied in the case upstairs?
Yes, Judge, yes.
Okay, so, we still have our conditions in place, correct?
No, Judge, the warrant deactivated them from the last one. Let me double check. Yes.
So let's do the same thing. No drugs, no alcohol. I'm going to test you like crazy. I've been doing it since the beginning, and I will continue to do it, Mr. Wyckoff. I don't want you using.
So when are we going to actually talk about the case?
We'll address that later.
I'm giving you a new lawyer now.
Yeah.
I want my paid attorney, the one I gave my money to.
So let's do this. I can call him, and I can try to get him here. Today's Friday. You have felony court on the 6th, which is Wednesday. If you want, I can put it on the docket for early next week, and I can try to bring him here, and we can have, you know.
That's how I got messed over last time. I was supposed to come to your court, but I went to felony court. They told me, don't come to your court, go to felony court. That's when you issued me a warrant.
I don't know. I mean, we'll have a hearing over it, but I'll get him here Monday or Tuesday, and we can talk about it.
And get him online like you usually do?
I'll send him a text, see what he can do. But regardless, though, you need to talk to him. You can't do that via
It's
Zoom.
like y'all both working together now.
So let me try to get him, and then I'll have him here. Okay. Okay. So I need him to stop. Be careful, Mr. Wyckoff.
Thank you, Judge. So do you want me to just roll it to next week or?
Yeah, let's put it on for Monday.
Monday? Okay.
Hey, Vic, we need to reach out to Mr. Gagliardi, let him know that Mr. Walker.
Are we doing anything other than no drugs, no alcohol?
No drugs, no alcohol, no weapons, no contact with the complaining witness. And that,
You want, no device?
not for now, he's the man.
Thank you, Judge.
Yeah, thanks. Right?
I miss Ogudo on your docket, Ogudo.
What's that one song? You know,
HOTT, yeah. Every time I say it. So I have a 4-year-old girl, so we're big fans of that song.
Mine too.
Yeah.
Okay. What's the word? I know.
I was getting old. State made an offer today for 30 days. So I really got to her.
30 days, Harris County Jail?
Yeah.
Are you happy with that?
No. But I'll relay to my client, as is my duty, and then we'll decide if we're going to take that or set it for trial.
Okay. So I'll give you a couple weeks. She's got to be here. At the next setting is play a trial.
Understood.
Yeah, okay.
Judge, did you want to call up the arraignment?
Yeah, please. Let me do this arraignment, Brock, and then I'll hit you up.
It's a transfer from court 1. I'm going to give y'all the case number. 8, 6,
Shush.
7, 5.
Shush.
Hold on. Oh no.
Page, right? The white one. Yes, just.
All right, the case number is 255-2544. Vargas, come on up.
How did she get here?
She went to court 1.
Oh,
It was
that's right.
a transfer with the Mendoza one. So they just sent her over here to.
So there's a co-defendant in this case.
Yes, Judge Mendoza, he's here too, but we're waiting on counsel to show up. And she said she was gonna ask for a court appointment.
Ms. Vargas, you're charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am. Okay.
Yes, Your Honor. On February 21st, 2025, at around midnight, officers in Harris County, Texas were patrolling Greens Point Drive when they observed a truck with expired registration from December of 2024. A traffic stop was conducted. Upon approach, the officer detected a strong odor of marijuana from the vehicle. After the defendant was removed from the front passenger seat and detained, a search revealed a marijuana cigar and a pistol magazine under the driver's seat. The officers located a black Taurus pistol with a loaded magazine and a purse behind the driver's seat. After being Mirandized, the defendant claimed that the pistol belonged to her friend's boyfriend and admitted that the purse was hers. Additional marijuana was found in a yellow backwoods container in the center console.
Was the gun found in her purse, near the purse? Because.
Yes, the pistol was found inside her purse behind the driver's seat.
Okay. But Ms. Mendoza, I'm going to find that there's probable cause to go forward with the case. How old are you, ma'am?
18.
I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to test you. If I find that you're using, it's not going to go well. Do you understand? I'm also ordering you as a condition of your bond not to be in possession of weapons. If I find that you have a weapon, likewise, I will revoke your bond, put you in jail. No more PR bonds, ma'am.
Judge, could I get the calls number one more time?
255-2544.
Thank you.
Thank you. Do you have the ability to hire a lawyer, ma'am?
Probably.
Do you work? What do you do?
I'm a hostess.
Did you graduate from high school?
No.
Okay, we're going to work on that as well. I will give you a lawyer today, okay? I need you to fill out an application. So Deputy Miranda is going to give you an application. I need you to fill it out for me. I'll have you talk to a lawyer here momentarily. But all I want are my streets to be safe. If I find that you pick up a new case, if I find that you're a danger, you break these conditions, it's really not going to go well for you. Do you understand? This is the only warning that you're going to get. So heed it well. Okay, come on.
Record flag.
The plea given on discovery not.
Oh, so.
Just those two.
Good morning, Your Honor. How are you?
Hey, bud, what's up, man?
Nothing much. Hey, man, I got Jasmine Roberson on docket. I put the cause number in the chat. She's gotten docket Monday.
Okay.
And so this is the one you've been having come every week until we get everything for the PTI program. I submitted everything Tuesday. We had court Monday. Unfortunately, I have not gotten it.
Let me verify it real quick, Brock, and then we can talk, okay?
Yeah, no problem.
Just make sure that everything's in.
Your Honor, by any chance, do you have a cost number?
Ready?
Yes.
251-8808. I'm going to do this plea real quick, Brock, while she's looking it up, okay? Ready?
Yeah, no problem.
Emmy Rivera, come up.
I'm sorry, Your Honor. One more time, you said 251.
8808.
8808, thank you.
So number one is inviting. It hasn't been signed yet.
You know, it may not be today. It may not be tomorrow. It may not be next year. But one day you're going to look at this day and you're going to go, why did I not make it work? You're in the PTI program. You've now been removed because of all these issues that we've had. You've now worked out an agreement, and what you need to understand that this DWI is going to go on your record. It will be there for the rest of your life. It's even there after you die. This is extremely important because if you're ever in a car and you get pulled over and you have the smell of alcohol, you have the smell of marijuana, anything funky, an officer, the first thing they do is they're going to look at your record. If they come up to your car and they smell funky, it's probably not going to go well. You need to understand that from now on, you will be facing a minimum of 30 days in jail. Any new cases that you pick up. Do you understand?
That's right.
You give up a lot of rights by entering this agreement, Ms. Rivera. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers, the right to be arraigned, charge resident for court. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, this isn't like Target, you can return it. It will go on your record. It will be there forever. Do you understand?
That's not true.
You need to understand one more thing, that you're allowed to make mistakes. But when you endanger other people's lives repeatedly, there are extremely serious consequences. When you pick up a second DWI, what your lawyer asked me to do, he asked me to do two things. The first thing he asked me to do was to roll your court costs and to take off the DPS supervisory fee. The DPS supervisory fee in and of itself is $3,000, not to mention the court costs, which are another $400 to $500 on a first. You pick up a DWI second, you're looking at a minimum of around $6,000 in fines and fees. Do you understand? I'm going to waive your fines and fees today. But if you pick up another one, get ready. Do you understand? For $50, $40, one button can get you a car to take you wherever you want to go in the city. It's a geographical oddity where it's $40 wherever you want to go. Don't matter. Use Uber. Do you understand? Me, I'm now going to suspend your license for a year. Do not drive at all. The other thing he asked me to do was to waive this so that you have no license suspension. With all the issues and the fact of this now, no, I am suspending your license for a year. Do not get into a car. Do you understand?
Yes, sir.
We're not asking for much. All we want are streets to be safe. Every single day someone dies, and it's just not fair. Don't kill anyone. How do you plead to the offense of driving while intoxicated? Guilty or not guilty? How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I'm going to sentence you to 24 days in jail. I'm going to give you credit for the 8 days that you've done. I'm going to waive $3,400 What is it?
Sorry.
It's okay. I'm now waiving $3,475. Do you understand? Good luck, man. Thank you. Thank you.
Your Honor, on that PTI, we did receive the mitigation packet. This guy's still reviewing it for.
Okay, are you missing anything?
I.
No, but first you got to get accepted first.
Right, yeah, so we don't know what she's missing until whether or not she's accepted or rejected. The way it works is that there's not a note saying.
So Brock, I guess let's set it out. You're set for Monday. I guess let's set it for the Monday after. And then I guess the Friday before, if a decision has not been reached, just let us know and then we can push it off a little bit further.
No problem. Your Honor, if you don't mind, can we do the 17th? Only because I'm out the Monday after. I'm out that whole week. That's spring break.
Yeah, I'm okay with that.
So we got the 17th.
Or 2 months.
Yeah. So I'm requiring her appearance for that setting, though.
That's fine, Your Honor.
Okay.
All right.
Done.
Thank you so much.
Okay. All right.
Have a great weekend.
You want to talk back, Chair?
I can also text your email.
Yeah. Or whatever. Yeah.
Sure.
Yeah, please. Yeah, let me just, we're close. Mr. Clay, you ready?
Yes, Judge. I have Nicholas Mendoza on your docket, Judge. For arraignment, he was transferred from court 1 this morning to court 5 today.
Did he just pick up a new case?
He did. He picked up unlawful carrying of a weapon, Judge.
Come up, Mr. Mendoza. No, it's on docket.
It got transferred from 1 to 5 this morning.
It's not on your document.
I don't have it on my
But I added it.
I don't understand how we have now another case. So since January, we're now working our 4th case.
4-6.
Yes, Your Honor. No, Your Honor. Speak up loud enough for this man to hear you.
Sir. You now stand charged with another unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On February 21st, 2025 at 12:23 a.m., officers in Harris County, Texas were patrolling 400 Greens Point Drive when they observed a vehicle with expired registration from December of 2024. A traffic stop was conducted. Upon approach, the officers detected a strong odor of marijuana from the vehicle. After the defendant was removed and detained, a search revealed a marijuana cigar and a pistol magazine under the driver's seat. When questioned about a firearm, the defendant claimed no knowledge of its location. Additional marijuana, 14.85 grams, was found in a yellow backwoods container in the center console. Continuing the search, officers located a black Smith & Wesson pistol unholstered underneath the back middle seat with a loaded magazine, but no round in the chamber. After consulting with the DA's office, charges were accepted as the defendant was under 21 years of age.
That the only reason? Being under 21? Or was it coupled with something else, other criminality? I mean, if it's just under 21, I'm going to have a problem with it. But if you tell me that there's weed in the car, then that's a separate issue.
Yes, Judge, it is the marijuana, and that's what the information states.
Let's see.
One for sure.
Right. Okay. So it says here, February 21, 2025, did then there unlawfully, intentionally, and knowingly carry on or about the defendant's person a handgun in a motor vehicle under the control of the defendant, and the defendant was engaged in criminal activity other than a Class C misdemeanor that is a violation of law or ordinance regulating traffic, namely possession of marijuana. Okay. Mr. Mendoza, I'm going to find that there's sufficient probable cause to go forward with your case. I'm now going to put an ankle monitor on you, and I'm going to give you a curfew of 9 p.m. to 6 a.m. I'm now also sending you for a drug test. I want to know what, if anything, is in your system, and I'm ordering you not to consume alcohol or illegal drugs. If I find that you're using anything as of today, you will go into custody. Do you understand? You're working on your 4th case since January of this year. I am not happy with you. Do you understand?
Yes, sir.
If I find that you have a weapon, if I find that you pick up a new case, if I find that you break curfew, it's really not going to go well for you. Do you understand? You're not to have contact with the co-defendant in this case as well. All right, so I'm going to send him for a test. He's to come back, and then we'll have the other bond conditions for him.
You bet, Joe.
Depending on how the test comes back, we'll have the reset. So if it's positive or something, then what we'll do is we'll set him off for 40 to 50 days for him to get, clean out, and then we'll do another test and we'll go from there. He will have a curfew. If he, and GPS monitor, he breaks the curfew, then you already know. I've already had to revoke your bond multiple times on your other cases. You know what happens.
9 p.m. to 6 a.m. means you're in the house by 9 p.m. and you do not leave the house until 6 a.m. Okay, clear. Thanks, Judge. And would you like me to wait around for that reset and for that, or?
I guess.
Or you get with me?
We'll get you the date, and then just leave your cell phone.
Absolutely.
That way I can call you, and then we'll let you know, or we can have you Zoom on.
You bet, Judge. Thank you so much. Did you like him to? Okay.
Mr. Weaver.
Good morning, Your Honor. How are you?
Hey.
Just wanted to, who I'm here on. Judge, this situation is easily distinguished from the first one. And the reason why I wanted to bring him in, I wanted the court to see his leg. It is completely chewed up underneath where this scram device is. He had a 0 blow. That's not the issue.
But do we not have a positive?
No, there's no positive at all, Judge. 0. It is.
Is the last name, right?
The RO, yes, sir. It's 250-6632.
Okay. So the BVR is, we have a confirmed tamper from 2/20/25, 2/37 to, for 2 days, we have a tamper.
Our vehicular crimes division wanted to object on this case, so if we could have a moment to reach out to them.
Yeah, Mr. Leeper, I guess you give me a second, see if we can get Mr. Silva here. Is she the one that's coming?
Yes, Judge.
Okay.
Thank you.
Yeah, do you mind?
No worries, Judge. Thank you.
For sure. Carl. Hey.
Talked to the bailiff. They tried to get Mr. Robinson up here. They're not going to be able to get him. He's still in the process and hadn't got through medical yet. So if you want to just carry him over till Monday?
I guess we have to, because I don't want to let him out without talking to him,
No.
Sucks.
And he also had the ankle monitor on when he went into custody yesterday. So you're going to, if you still want him to have the ankle monitor, I guess he'll have to have it put back on.
Yes.
Yes. Mendoza, Nicholas?
Theoretically, you could possibly maybe over the weekend at some point in time, maybe call the magistrate and have authorize a PR bond.
But then I have not been able to talk to him. And the problem is that I want to admonish him,
No.
That's.
The judge, I'm gonna tell you something right now. I've talked to him probably worse than what you do.
Huh?
I said, I probably talked to him worse than you do, quite frankly. Even though I don't have the quote unquote authority behind it. But,
those,
I know.
Let me see. Give me a second. We put him in custody Wednesday, right?
No, he took me to custody yesterday.
Hey, do you have a second? When is that gonna end? Dang it. I need to know when someone is, why they haven't been processed and where they are in processing. because I wanted to kill. Cause number is 2544-664. 2544-664. I have someone looking into it, and what she just told me, I called the court manager's office, is that they have a big backup at the JPC where they have double the amount of people that they normally do. So that's what's causing the holdup.
They had computer problems last night.
Oh, is that what it was? Yeah. That must be why. So I have her looking into it. I have your cell phone. Let me figure out where he is in the process, and then I'll reach out to you as soon as she reaches out to me.
Okay.
Let me see.
I got 2 other courts. I can bring you back. All right. Thank you, Judge.
And
May I approach, Judge? I'm approaching on Hunter.
On who?
Hunter. He's got.
Patrick Hunter?
I'm sorry?
Okay. Is he here?
He is here. He has a BVR, but before we address the BVR, can I ask you to hear PC?
Haven't I already found PC?
You have, but there is a disconnect between what is in the DIMS and what the body camera shows.
I can't get into that now because that gets into more than just, you know what I mean? That we would do for like a suppression, but when you start getting into evidentiary things, like that gets into more outside of a scope of, because I have to give them the opportunity to respond to that too.
So I spoke with the state about this yesterday, and I don't know what has come of that.
I mean, I want to be fair to you guys, right? And when at a PC hearing, when someone starts getting into body cams, into videos and.
My point, Judge, again, I'm relatively new to the courts. I don't really know how the court policy is on that. So
I'm always happy to rehear PC something on anything. But when you get into using evidence into a PC hearing, like, I guess that defeats the purpose because it's just supposed to, on its own, there's either PC for the PC hearing or there just isn't.
On the face of the DIMS, I'm going to argue there's no PC. This case was charged as having a gun in plain view. The officer in the DIMS, what he swore to, the gun was between the driver's seat and the center console. If it's between.
Well, it was like the butt of the gun was visible, right? If I remember.
But that it has to be immediately apparent that it's a gun. And the reason I want you to see the body camera is within the first 2 minutes of the officer approaching the car, he asks Mr. Hunter if he has a gun. Mr. Hunter tells the truth and says yes. And the next thing the officer says is, where is it?
I get it. I need to give them time to look at it though. You know, I mean, to be fair, both sides have to have the opportunity to look at what you're complaining about, that there's no PC, because they haven't now had the opportunity to look at what you're saying. So me would be me allowing you to get into evidence where they've not been able to see it.
Well, it's their body camera.
I know that, but they're not prepared now. I mean, imagine we have 100 cases every day, you know? And it's just kind of like springing it on them. Hey, by the way.
Here's what we can do, Judge. And this is okay. We get a setting for hearing.
So
we want to have, because anything body cam, I'd like to at least have an officer explain it.
Okay.
I think it's unfair to the officer to have just his body cam played before without any kind of context. But what I will do is I will look at the body cam as well. We will look at the body cam as well, evaluate it there.
I'm always happy to do it, but I want to be fair to them too, you know?
So this case is set for trial, I believe, on March 18th. My concern is that Mr. Hunter does have an allegation of a bond violation. And if he goes back in and there's no PC, he's being held on a case where.
PC's been found. I found PC. There is probable cause to go forward now. You're just saying, in your opinion, that there's no, after further looking through the evidence, so you're saying he's not guilty, right? But there is probable cause to go forward. I found probable cause. You're just saying that he's not guilty because, you know, the video may not show what you think they're alleging.
Okay.
But, you know, regardless, come up, Mr. Hunter. He's testing positive over and over for meth.
No, he missed a drug test on the 18th.
Come on.
And if you send in a test today, he will be clean.
I'm sending you for a test right now. I want to know what, if anything, is in your system. Do you understand?
Yes, sir.
It's now 11:30, so I guess we'll have to put it off for Monday,
Okay.
but,
Starting Monday, Friday, we're gonna see messages.
where did I see somewhere that was alleged that there was meth or?
That was his first drug test back in,
Okay. So he was just a no-show at that time.
Yeah,
Okay,
he just-
I'm sending you for a test now, Mr. Hunter.
okay.
So if it's negative, great. If it's not, we'll deal with it when we get there. But I'm sending you for a test now. If you ever fail to show again, I will put you in jail. Do you understand? You know better than anything. You have to show up to these tests. You know. Okay, so just have him take a seat. Well, I'll have him sent and then we'll roll to Monday.
And this case is set for trial on the 15th. The state has already filed, I think, their pretrial motions. Is there a way we can move it up and we'll waive the 20 days?
You speak to them. I'm
Okay,
happy to do whatever you
I
want to
just
do
don't
as long as they're
trial
in
dates you
agreement.
have.
Sorry?
I just don't know what trial dates you have.
Ramona's back there.
Okay.
She can tell you.
Okay.
But, if we're going before, you need to get their approval.
Okay.
As far as, waiving any kind of
Well, if you were going
lines.
to be here next week, or if you were going to be out, there's no point
I'm
in
not
asking.
going anywhere.
Okay.
I never go anywhere.
You need a vacation, Judge.
All right. You ain't lying. Okay, Mr. Hunter, take a seat. I'm sitting.
Okay.
Thanks, Sam.
Sit down.
Yes.
Judge, good morning. I'm approaching on two cases. The first is Mr. Verwin Cooley, COO.
So you got appointed to Mr. Cooley this morning, right?
Yes, Judge, I was looking at the case. I wanted to see if we could hear PC on this one.
Okay, please.
Can we call Mr. Cooley?
Sure.
February 21st, 2025, an officer observed a white Nissan Sentra without a front license plate. A traffic stop was initiated. The officer made contact with the defendant driver. The officer observed the odor of marijuana. The defendant admitted to having a cigar blunt with marijuana inside the vehicle. A probable cause search was conducted. The officer observed an electronic scale in the front driver door panel, a full cigar with marijuana inside, tucked in near the passenger seat and center console, and a
Can I
large
get an argument,
plastic bag containing approximately 0.016 ounces of marijuana.
You ready for it? All right, Judge. So in Texas, we can't distinguish between hemp and marijuana. The only thing that distinguishes it is a concentration of THC in the substance. We don't have a lab report. He could easily have said, hey, it's marijuana, and thinking it's marijuana, but if it's hemp, it's not illegal to have it. He could be under a mistake of fact or a mistake of law. So he doesn't know. He didn't give him, hey, here's a lab report of the substance that's in there. They don't have a lab report. They can't tell me if that's marijuana or if it's hemp, which is legal. It could be either one of those substances.
I think that there's probably a totality of circumstances, and not to mention the admission, that makes it enough for probable cause to go forward. Now, if the lab report comes back and there's something different, okay. But for probable cause purposes, I think that there's enough to go forward.
Without the lab, just being clear, we don't have a lab at this time.
I think that there's enough to go forward.
Understood. Thank you, Judge. All right, have a seat, Mr. Cooley. I'm going to bring another client out for PC. In a moment, I'll let the other counsel, Mr. Alvin.
Good morning, Your Honor. I'm reflecting on Baptiste. I had filed a motion to sub.
I saw it. I signed it.
And to my understanding, you told my client that you won't be able to offer him a fugitive bond, but we were gonna.
A what?
A fugitive bond. You said no.
I don't remember. I mean, we've had so many kids. I don't.
But I'm on, but we're gonna reapproach.
I'm happy to hear it.
So the only question, but I do have a question though. So if I have a client that has a fugitive warrant, the other court controls their court team? Or does this court?
No. So is he on docket today?
No.
So what happens if someone has an open case elsewhere?
Okay.
And they've not made bond on that case?
Okay.
This fugitive case is put on hold. It's told until they either make bond on the case upstairs or they dispose of it somehow. They plead or it gets dismissed.
Wow.
Then if they have waived here, the 14 days starts running. If they have not waived, then we need to bring them back to do all the, either the waiver, either a bond, or we get a governor's warrant.
Got it. Okay.
And the governor's warrant takes another 90 days. So do you know, have they made bond? Is it a felony case?
Well, he made bond on his felony case.
He made bond.
The case is out of Maryland.
Right, but
He made a bond on his, yeah.
Did he refuse here?
No.
He waived? So the 14 days has started ticking already from the day that he made bond. So if it's been like a week, he probably has some time under his belt. I don't know.
Okay.
But
It's back on your docket next week.
okay.
So we'll just
if you want to move it up,
Okay.
can, but we got to let Day know, Mr. Kim, Day? Kim?
Oh, yeah, I do.
Let him know.
Okay.
Rope him in and then I'll do whatever you want to do. If you want to do it again, we can do it again, but no promises, right?
Thank you so much. Thank you.
Sure.
Judge, this is Mr. Pierre Alexander.
Mr. Alexander?
Oh, yes, Judge.
Okay. Good morning, Mr. Alexander.
We're in front of you today on a evading case, Judge. I want to see if you hear PC on this one.
Okay. Oh, he has a fugitive case too.
Yes, that was appointed previously on the fugitive. It's out of Mississippi, but he's got an evading, which we're dealing with today.
Okay, and the bird, he's got an open bird habitation.
Yeah.
Okay, all right, so Mr. Alexander, you're charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, sir.
Okay.
On February 20th, 2025, at approximately 1:00 p.m., the officer was conducting a proactive investigation of a burglary of a habitation in Harris County, Texas. The officer was in plain clothes and driving an unmarked police vehicle. The officer saw an individual matching the description of the suspect caught on ring camera burglarizing a house. The individual was later identified as the defendant. The officers observed the defendant crossing a road where no crosswalk was provided. And then the plainclothes officer advised a marked police unit to stop the defendant and ID him for the traffic violation. The officer approached the defendant in the marked police vehicle with emergency lights activated. The defendant noticed the officer and began to run through an apartment complex. The officer drove into the apartment complex and the officer in plain clothes drove into the apartment complex and he was able to cut off the defendant and apprehend him. The defendant evaded for approximately 300
He didn't tell him to stop?
So, but he was.
No, we don't work on hunches, right? You can't assume anything.
I'm not, Judge. I'm saying that he saw the emergency lights were activated and he ran away from the police officer.
Did he tell him to stop?
No, Judge.
Yeah, no problem cause.
Thank you, Judge.
Of course.
What's this on? We'll talk right now. Who's gonna talk?
Alexander.
Please.
Mr. D.
Yes, sir, Your Honor.
Come on.
The chief and I, we're back on Mr. David Shaw. I think the chief tried effortlessly to get in contact with the apartment complex to see if there could possibly be any arrangements made to.
But it's moot while he's in custody anyway, is it not?
I think there's concern that he's gonna bond out because it looks like Felony had him on PR bond.
I said it's bond at 5,001.
But it looks like on the new one, it's 500. Was that reset? Was that set down to 5,001, Your Honor?
Ours is our first case is a 5,001. He has not made that bond.
Okay.
On the second case that he has, I think it's 500. And the magistrate gave him a PR bond on that one.
Yeah.
I didn't touch that one. I only revoked the first one because of the new case. So, but
So, a couple things, Your Honor. I do think there's a concern on the state's part that you will bond out and go back.
Okay.
I do know, though, I talked to the pretrial, it looks like there's a bond violation report that is waiting to be signed by the judge up at but it just hasn't been signed yet. So I think once he.
So you're telling me that they're going to revoke the bond?
It's going to be up to the judge up there, but I don't know. The bond violation report hasn't been signed by the judge. And he got that PR bond from Felony 5 days before the indictment. So I don't want to put words up in the district court judge.
And I don't want to, Judge,
so how do we?
I don't want him to go back. I don't want him to put himself in danger or the complaining witness in danger by going back to the facility where he resides in room 320 and the complaining
So you
witness.
talk to the complex?
I'm trying to. I've called them a couple times. I haven't answered. You know how these things are. Offices.
You want to try and just roll it to Monday and see if they respond back to you and see if there's.
That's fine.
But the problem is that it's like.
You know, they too close together, Judge. Somebody drink a beer and she say, that's the guy that allegedly did this, that. It could be a bad situation. I mean, being that close to each other.
That's the state's. I think there's a major danger to the community if he goes back there, both to himself and to the family.
Did we order him not to go back to the complex?
It was 500 feet.
We said 500 feet, but that's like.
But he hasn't transferred to that 500 feet. He's still in 320.
Right.
That's not 500 feet. So hypothetically, the only place he has to go is that place. And I'm afraid that someone could get hurt because if her boyfriend or something comes over and she tells him, this is the guy that did this in my presence, he's not going to let nobody hurt him, and he's not, and he,
Hopefully they reach out to you. Let's roll it to Monday. See what they advise. Do they have any advice? Do they have, because.
I think that's what we were trying to see is can they move him to another, or even if he's even allowed alcohol. I don't know if they've been, I don't know anything. So it may be rolling to Monday. We can get. I just want to make it.
We have a GPS monitor prior to release, do we not?
Yes, sir. Yes, sir. We do.
So I guess if he does get out between now and Monday, just please let him know.
That the monitor will let him know if he's within 500
Don't
feet.
go back for now. We need to figure out another solution to this issue.
Yes, sir.
And, we're amenable to another solution. Just, we don't want you to run into this person.
So you have to find another place to stay during this, at this time. Okay, I'll let him know right now, Gary.
Is she here?
With permission, Judge, we've been told to move ahead.
All right.
Okay.
If it's
She's
okay
got too
with the
busy.
court.
I spoke with her and she said it's okay for us to approach on that. So I apologize for that.
All right, Judge, and just to distinguish where we're at, this was not an alcohol event at all. He's been.
I don't know that. How do I know that?
It reads.
I know that, but what in these instances, what happens is someone puts something in between the leg and in between the device to be able to subvert any kind of reading. That's what happens. So when you see something where there's no contact with the skin for a certain period of time, here it's 2 days, there's no contact.
And that's exactly why we're here, Judge. And I showed the prosecutor his leg, and we've been having issues with his whole entire leg is completely chewed up because of this device. It is.
But the solution is you come to court, you say, hey, I need to switch it to another leg. You don't just on your own initiative start sticking a piece of paper or a towel or something in there,
Judge, I get it. I mean, just there's a tamper event doesn't mean it was intentionally done. And he's on GPS and
there's no way for us to know. All I know is that it broke contact with the skin for 2 days.
I agree.
Come up. I appreciate your tenacity, Mr. Leeper, but he has a DWI. He's got an FSRA where we have a dead body. He's not one violation. We're now working on our second to third violation, and now you're putting something, or I don't even know, but all I know is that the device lost contact with your leg for 2 days. That is unacceptable. When you have issues with a monitor, you bring it to your lawyer's attention, you come to court and you say, look, this is what's happening. You don't put something in there in hopes that we're not going to notice. And now you tell your lawyer after the fact. I'm sorry, Mr. Lee, but what choice do I have but to revoke his bond again? You know, I know that it's upsetting, but no, I have a very serious case with you. You've been ordered not, you know that there is no tolerance in this case. Yet, you lost contact for 2 days. I'm revoking your bond. Go to jail. Sorry. I'm sorry, Mr. Leeper. I mean, I don't know. Judge, I'm not getting through.
Well, this is the other side of it too. He can't switch legs. He's got a GPS on his other one. He should have, I agree with you, this court, I agree with it, but something's good. We're gonna have to change something, or even move him to like a full-time portable blow, because it's not an alcohol issue, Judge. And, he obviously made the mistake.
I don't know that, right? Until you come here and tell me, I don't know. The only thing I know is we have a DWI, we've got an FSRA, we've got a dead body, and I've got multiple violations. And now you're hiding, you're doing something 2 days that I don't know about? You know what the proper procedure is when there's an issue. And you're just not doing it. You do what you want to do. That's not the way it works. And now you go to jail. Goes with you. I'm sorry, Mr. Leeper. I can't continue to justify it.
Fine, Judge.
He does bond out. We'll craft a different solution. I'm all ears, but I'm not going to let him continue to subvert.
What's his bond set at?
10,002. I mean, it doesn't make me happy, but I have to let him know that I'm serious, and you go 2 days, you don't have it. You've lost contact. I don't know what he's doing in 2 days.
This is the thing that frustrates me about these devices. He doesn't know he's lost contact. That's a whole. We don't get an alert saying that he's lost contact. He didn't know until this thing came in, and so it's on his leg. He's showing up to work. He's back home on time.
The device is snug to your skin. It's literally, it has to have constant contact with your skin. So for it to lose contact with your skin, there's something in between it, or they've done something to it. They've loosened it to where it's lost contact. They've put something in there. That's why it's impossible for us to know. The only thing that we do know is that it lost contact and it lost it for 2 days. Yeah, if it was our first rodeo, if it was our first, I always give someone the benefit of the doubt. But here we are over and over and over. And I've admonished him the last time. If you ever have any problems, you come to us. You don't do things on your own.
Thank you, Jeff. I agree, Steve.
I'm sorry, Mr. Lister. So, look, he'll end up bonding out. When he does, come back and we'll talk about it and we'll figure some solution out. My only issue is that if I give him a portable device, he's going to start skipping blows. That's why we have this grant. But I'm willing to give him an opportunity to let the leg heal, give him a portable device.
Keep him on GPS and keep him on curfew.
Right. Same thing, but I'm telling you, if I start seeing skipped blows, we'll have an issue. All right.
How much was that?
10,002.
10,002?
Yeah.
If he bonds out, then we're gonna get that.
I think it's taking right. And then we'll just figure out what other things.
Okay, that's good.
Are we done?
Go over.
Come on, man.
Page 1, both defendants set for arraignment fell to their first time.
2501 on both.
Page 2, Edwards, same thing, Judge. I even went to the bond paperwork and called the defendant
Okay.
and all the numbers listed.
5,001.
5,001?
Yeah.
Page 5, Jones, Michael. Set for arraignment failed to appear.
And he picked up a new case while he's on bond, right?
Yes, sir.
Okay, so I got to do a bail order on this dude.
But the one on docket today is the new case. So you're in the old one?
So, no, I guess let me check it out. When's the old one set?
And the new case, I mean, the paperwork says today's date.
Right. So the old case is on for today.
The old case, no, on
Yeah.
docket today is the new one. That's a new law violation, the new case.
The mischief is on for today.
Yes, that's the new
Right.
one. Set for arraignment, bond paperwork is today's.
Okay, 5,001. And we'll keep the terroristic threat on for Tuesday, I think it said.
Wednesday.
Yeah.
Vargas, Melissa?
Sure, sure.
Sorry.
No, it's no worries.
It's coming here.
See what I mean?
Yeah.
Melissa, I'm just. I'm gonna go to my today, I'm gonna have something fine. I'm gonna be shot with everything in front of me. So.
Basically.
You're going to be appearing court every time your attitude, your criminal no law violations.
Carter, we're waiting for the state to file.
Bond conditions, yes, okay, I'll work.
This is a good one.
Okay, now.
Starting Monday through Friday only.
Thank you.
You're going to receive text messages from a system called Abraham. And it's okay on our screen. It says yes, hours, that's and then this is your personal identification of the stop. It just depends if it's something you find. But you know, that is because you're so that English requires the drug listing process. Just make sure to respond to those texts. Text messages that are yes. I'm going to send you times, information, and then I will send you on the way.
Who's next?
No driving. I don't think I have to sign first time.
What's new? How are you?
Nice to see you.
You too. How are things? Good?
Yeah, cool.
Cool.
Page 13, Stone, set for arraignment failed to appear.
2501.
All right, Judge. That's it for the bond docket.
Okay.
To clarify for Jones, did you revoke just the one on docket today?
Correct. Yeah, we'll wait for the other one for that day.
Okay. And then for Hunter on page 5, you sent him for a drug test. Did you want him to come back?
Monday. Yeah.
On Monday or today?
No, Monday. Monday.
Okay.
Yeah, I got to jet out.
Okay.
Judge, we're still waiting on
I'm still working on bond conditions.
Mendoza. You wanted Mendoza to come back today.
Uh,
Are you able to send them a message to just come back?
Yeah, I can do that. Am I allowed to? Sorry, am I allowed to hang out with?
who did I just put in?
No.
We just put Viharo.
Did I put another person in too?
Again.
It was just Viharo, I'm pretty sure.
There's no one else?
Judge, we did need to go over Rubio and then printout. Hey, Anna, we're rolling Hunter for Monday.
Okay,
and
all Thank you, ma'am. Here, I'll be here in my seminar costume.
Oh, do you? Yeah.
We'll follow up right now. Hey, Victoria, so they're not documented today.
Okay, so I'll put it on March 31st.
All right, so Victoria, that's the strip here, or the number.
Yes.
What?
That's
That's doing the bill. Then it's your police, where that bond is doing.
Yes.
Miguel Lopez, the CEO.
Yes, exactly.
I'm pretty sure, I would check.
And, you want the felony?
Yeah, felony, 4-2.
4-2, yeah. They want 4-3. All right,
Yeah, just we talk to them with 1 minute, and then I'll send that, I'll let you know. Yes. And so they didn't follow the so they had 2 months. They did all different one. I think the whole rules are not true.
Okay, what else?
Judge, that's it. Except for Rubio. Did you sign the bond conditions for Cooley?
I don't have them yet. I'm still waiting for them to come through for the open box.
Oh, that's.
I just got those.
Oh, okay.
I haven't gotten it. Let me reach out.
Okay, they're in your queue, Judge.
He's still in the booking process.
I figured as much.
I guess let's.
Be here Monday.
Yeah, we'll be here Monday.
Okay.
And
Thank you, Judge.
sure.
I also got I got an update on the Nellums. Nellum, the one from Thursday
yeah.
with Dave.
Okay.
She won't be released from her felony case till tomorrow.
Okay.
So then I hopefully over the weekend, I guess. I already showed Dave. He was surprised that they were doing future release dates. But I guess that's when everybody to be released with the backup.
You're Mr. Cooley, right? Coming up, we'll have you sign your conditions. What is your last name?
He was the one that was bonded out of county. He's still in INN status on our screen, but he has a out of county bond. He's off the judge.
Oh. Vic, do you have the cause number on Rubio, please?
Yes, Judge, it is 2472951. It was an MAJ warrant, and then he posted bond. So the warrant's executed. So we would treat it like an arraignment today.
Where's the lawyer?
I don't know.
So let's roll it to Monday so we can get the lawyer here.
Okay.
So a motion to adjudicate has been filed, right?
Yes, Judge.
Come up, Mr. Rubio. Guys, do you have a cause number for this? I'd like to know if there's a valid Texas driver license or not, please.
His driver's license is ineligible, Judge.
This is an affidavit that you're going to sign right now, promising me that you're not going to drive. In the short life that we have, I don't give a rat's behind what an excuse is. You cannot justify getting into a car and driving for any reason whatsoever. I don't care if there's a child that has to go to the hospital. I don't care if there's a burning building where you have to save 50 people. If you do not have a license and liability insurance, a Texas driver license, you are not allowed to drive. Do you understand? Yes, if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. It's an offense in and of itself. Do you understand? Sir. You need to have your lawyer here. I don't know why they're not here.
I was contacting him.
We are going to reset your case Monday. Get in contact with your lawyer for this weekend. You must also bring your bonding paperwork so that we know that you bonded out. Yes, sir. Because I don't see it. They haven't seen it. All I show is that it's in warrant status. There's a screen that you say that bond has been posted.
Yes.
Oh,
So it still reflects open warrant because there are two JPs, right? So ours says we were executed per bond being posted. So the Y.
bring the paperwork just in case next time. And then we'll see you Monday. Here, swear to us that you're not gonna drive and then we'll get you out of here.
Bonds, we keep bond paperwork due. So just go ahead and sign the bond. They use one of the ones.
Get you going. You got anyone else in back? Guys.
You signed this one, but you were not motor vehicle without a valid. Oh, yeah.